George asked who should speak first. I think in retrospect, she should have spoken last. She's got the solution to the problems that Ben and I are going to discuss. So you'll have to bear with us when we talk about the problems, knowing that you've already heard about what the solution to those problems are. We all know that war is not healthy for human beings and other living things. And it's no surprise that war is not a healthy thing for civil liberties either. The military-industrial complex, by definition, its purpose and goals is to keep us in a state of war or preparedness for war. And we don't have to guess at what the impact on civil liberties will be. We have sufficient historical antecedents to know what the impact of war has been on civil liberties, and I want to share a few of them with you. In 1798, not long after the adoption of the Constitution and the Bill of Rights, the Federalist-controlled Congress made it a crime to criticize the government. They claimed, under John Adams, that this was necessary in light of the heightened tension between the United States and France, something that was reflected, I think, a couple of years ago as well, when we sought to rename French fries into Liberty fries. But all of those charged were from the opposition party under that statute. Our hometown boy, Thomas Jefferson, came to office and pardoned all the people who were convicted, and the law expired of its own terms. The great emancipator, Abraham Lincoln, in 1861, suspended the writ of habeas corpus. Tens of thousands of civilians suspected of being disloyal to the Union cause were detained by the military without charge. A case called Ex parte Milligan reached the Supreme Court in 1866 after the war. This is what the Attorney General for the United States argued, that the legal guarantees set forth in the Bill of Rights were, quote, peace provisions. During wartime, he argued, the federal government can suspend the Bill of Rights and impose martial law. If the government chooses to exercise that option, the commanding military officer becomes, quote, from the supreme legislator, supreme judge, and supreme executive. Now, this case reached the Supreme Court, and the Supreme Court held that Lincoln did not have the authority to suspend the writ of habeas corpus while the legislature was still in session and while the courts were still functioning and not subject to the rebellion. And it's very interesting what they said when they wrote the opinion doing so. And I quote, "During the late wicked rebellion, the temper of the times did not allow that calmness in deliberation and discussion so necessary to correct conclusion of a purely judicial question. Then considerations of safety were mingled with the exercise of power, and feelings and interests prevailed, which are happily terminated. Now that the public safety is assured, this question as well as others can be discussed and decided without passion or the admixture of any element not required to form a legal judgment." In 1917, after the Russian Revolution, this country engaged in another acts of repression. The Palmer Raid, the deportations of people who were thought to be subversive and a danger to this country in light of the Russian Revolution. The Espionage Act of 1917 made it a crime to willfully utter, print, write, or publish any disloyal, profane, scurrilous, or abusive language against the United States. In 1919, shortly thereafter, the Supreme Court upheld the conviction of socialist Charles Schenck, who had printed and distributed pamphlets urging opposition to the draft. And the great Oliver Wendell Holmes wrote, "When a nation is at war, many things that might be said in times of peace are such a hindrance to its effort that their utterance will not be endured so long as men fight." Another great icon of American liberalism, Franklin Delano Roosevelt, signed the declaration that placed Japanese Americans on the West Coast into internment camps. That act, that outrageous act of racism and of a violation of the most fundamental civil liberty, though that of liberty itself, was upheld by the United States Supreme Court. And it wasn't until 1971 that Congress passed what is now called the Anti-Detention Act, which is designed to prevent that happening in the future, that actually Ronald Reagan awarded the Medal of Honor to Korematsu, the gentleman who was brave enough to be the plaintiff in the case that was lost in the Supreme Court. And the Congress issued an apology to Japanese Americans and offered some minor amount of reparations for this heinous act. The McCarthy era, the Smith Act made it a crime to knowingly or willfully advocate, abet, advise, or teach the duty, necessity, desirability, or propriety of overthrowing or destroying any government in the United States by force or violence. In 1971, during that era, the Supreme Court upheld the conviction of Eugene Dennis and other leaders of the Communist Party for conspiring to organize that party, because the party stood for the overthrow of the United States government. It wasn't until 1969 under Earl Warren and that court that they ruled that the government could not prohibit advocacy, even of unlawful conduct, except where such advocacy is directed at inciting or producing imminent lawless action and is likely to incite or produce such action. In another case in the Warren era, where reflecting on another statute that was passed during the McCarthy era that prohibited members of communist action organizations from working in defense plans. This is what Earl Warren said, and it rings true today. It would indeed be ironic if, in the name of national defense, we would sanction the subversion of one of those liberties which makes the defense of the nation worthwhile. The phrase war power cannot be invoked as a talismanic incantation to support any exercise of power which can be brought within its ambit. Even the war power does not remove constitutional limitations safeguarding essential liberties. The worst part, in my view, of the McCarthy era was not simply making membership in organizations a crime, or that membership in political parties a crime, or that membership in certain political parties with the Communist Party disqualified you from elected leadership in unions, or even prevented you from getting a driver's license, as occurred to the head of the Communist Party. But what was put in place was a process of fear-mongering and intimidation that led to the greatest danger, in my view, to civil liberties, self-censorship. And it wasn't until a decade or two later that we started to emerge from that period of self-censorship. We faced similar problems in the War on Terror. Shortly after the attack on the World Trade Center, the United States Congress, with one dissenting vote, as I recall, in the Senate, passed the Patriot Act. There was no debate, no discussion. It authorized the executive branch to conduct searches and seizures of medical records, educational records, financial records, library and bookstore records on less than probable cause standard that's set forth in the Fourth Amendment of the Constitution, so long as the FBI certifies to a judge that it is engaged in a terrorism investigation. The word terrorism then replaced the word communism as the basis for suppression of civil liberties. The law even made it a crime to disclose the existence of such a search and seizure order. The Act also established new crimes such as providing material aid to a terrorist organization. The National Security Agency engaged in extensive wiretaps, which were claimed to be supported by the President's, quote, well-recognized inherent constitutional authority as the Commander-in-Chief and sole organ for the nation in foreign affairs to conduct warrantless surveillance of, quote, enemy forces for intelligence purposes to detect and disrupt armed attacks in the United States. In this case, the President acted in direct contradiction to the Foreign Intelligence Security Act, which itself had provided a secret mechanism for the government to obtain permission from a hand-chosen court to engage in wiretaps that they claimed affected national security. The President asserted the authority to declare even the United States citizen an enemy combatant, and to put that person in a military grade and to hold it there indefinitely, not only without a trial, without any form of due process, without any form of process whatsoever. The United States President asserted the power, and continues to assert the power, this President, to execute even American citizens abroad if they're felt to be a danger, not because they're engaged in actual acts of warfare, but because of their speech. As I said, the implication of terrorism, like the implication of communism, has skewed the balance in the courts as well as in the public sector and in the legislature. I'll give you some examples of some cases I worked on. Brett Barson, the director of the South Carolina Progressive Action Network, was arrested in 2003 while protesting President Bush outside the Columbia Airport for violating an unannounced restrictive zone surrounding the president who had yet to even arrive at the premises. Thereafter, and you're all familiar with it, protesters have been required to confine themselves to so-called free speech zones that were isolated them and marginalized their protests. I worked with United for Peace and Justice in New York. United for Peace and Justice was denied the right to march down First Avenue in front of the United Nations because of the alleged threat of terrorism in the front of the United Nations. I represented United for Peace and Justice when it was engaged in the protest against the 2004 Republican Convention in New York, and we sought to have a rally on the place that had been the primary place for rallies in New York City, the Great Lawn in Central Park. And as I argued that case in front of a state court judge there, after I made the argument, she said to me, well, everything you said about the First Amendment is true, and everything you've said about public forums and the right to protest is true. But Mr. Fogel, this is a new day. That new day, of course, she meant was, we are in the city that was attacked by terrorists, therefore you don't have the rights that you used to have. And in ensuing conventions, just like in the convention in 2004, the police have engaged in infiltration of political groups, raids on their headquarters, and the kinds of operations that we remember from COINTELPRO that were designed to disrupt and destroy the Black Panther Party. And those people are also confined to free speech zones. In New York City, we have a permanent national security state. There is a little CIA within the New York City Police Department, headed by the former operations director of the CIA, trained by the CIA. I worked on a case with the New York Civil Liberties Union challenging the CIA, the little CIA, if I can call it, imposition of a bag search in the New York City subway system. Now, anybody who's been to New York knows that when you enter the subway system, it's no different than a street in New York City. There is nobody, unless you're rich, who can move about New York City without utilizing that subway system. Now, anybody can be searched and their bag searched who enters the subway system in the city of New York, and that was upheld by the Second Court of Appeals. Now, the standard that was applied in upholding that was a standard that would be allowed to apply to searching anybody who had a bag, a pocketbook, a briefcase, walking down the streets of any city of our country. Now, it hasn't happened, but the legal precedent has been put in place. One of the hallmarks of the constant state of war, and one of the greatest threats to democracy itself, is secrecy. While the president promised transparency in government, the Justice Department repeatedly argues, and often with success, that the courts are not open to cases that might reveal, quote, state secrets. And we're not talking about how to make a nuclear weapon, but virtually anything that the intelligence community does, for example, extraordinary rendition, which I think people in this audience are familiar with, or that might reveal or harm our relations with other governments. Every first-year law student learns the first case that was of significance in the United States Supreme Court called Marbury versus Madison. And one of the lessons we learned in that first semester is that where there is a right under the Constitution, there is a remedy in the court system. That has been turned on its head. In this new paradigm, though your Bill of Rights may be violated, there is no remedy in the courts of the United States when the government successfully asserts the state secrets doctrine. And look at the efforts of the government to prosecute Julian Assange for helping to reveal the kind of important information that citizens in a supposedly free society need to judge their own government. That government which is supposedly of and by the people, and their political leaders as well. I have to mention one other war that has had a significant impact on civil liberties, and that has fostered its own industrial complex, and that is the war on drugs and the prison industrial complex. This has also been one of the gravest threats to civil liberties in the past several decades. One aspect of which was characterized by one courageous Supreme Court justice as the, quote, drug exception to the Fourth Amendment. But the hidden horrors of mass incarceration have followed that drug war, and the result in part has been the development of what one wise professor of law has called the new Jim Crow. And that cannot be ignored as we move in the future. In past wars, as I have noted, civil liberties have been one of the casualties, but often when the war was over, as I've noted, we've recognized either the error of our ways or that curtailment of liberties was no longer necessary. Now we face what our politicians and some of their friends on courts and many of their friends in the media call a war without end. And we thereby face a threat to our liberties without end. What is encouraging, on the other hand, and is apparent here, is the fact that so many people refuse to be silent today. Because after all, neither civil liberties nor social justice have been or will be achieved or maintained without organized resistance to repression and the demands of the citizenry for social justice. Peace and liberty will come at home and abroad not as a result of the so-called victories of war and the concomitant repression of civil liberties,